Thank you, Victoria, and good morning, everyone. It's such a pleasure to be here with these three women who I know and am so happy to be able to talk with this morning. I'd like to start by saying that UBC's campuses in this region are situated on the ancestral unceded territories of the Musqueam, the Squamish, and the Tsleil-Waututh peoples, long the caretakers of land, nature, and culture. And I'd also like to acknowledge that you are joining us from near and far today, and I'd like to acknowledge the owners of the land that you are on. And we all respect and honor our original peoples of this land. So I'm just going to say a few words, who I am and the format of the day, and I'll introduce the speakers and then we'll get going. So as Victoria said, I'm Linda Nowlin. I am an environmental lawyer by background. I joined UBC as the Senior Director of the UBC Sustainability Initiative just last summer. And I'm an adjunct at the law school co-teaching an environmental law workshop. So the format today, we're so pleased to be able to talk about BC food system governance. It's a very place-based discussion that we're having today. And as I mentioned, I'll introduce now each of the three speakers, one after the other. We're going to hold questions and discussion until after all three speakers have had a chance to do a presentation and share with you their knowledge and experience. And then we will have a discussion between the speakers and me, and we will open it up to you, the audience. So that's the format for this morning's panel. So on to introductions. What a pleasure again it is to be here with friends and colleagues. So I will introduce them in the order that they will speak in. First of all, Deborah Curran, who is an associate professor at the University of Victoria Faculty of Law. She's also the executive director of the Environmental Law Center at UVic, a really successful student organization, well, university organization that places students with partners and clients to do really groundbreaking work on environmental law. Deborah teaches land and water regulation, and she has a real specialty in working on the intersection of colonial law and Indigenous law. She's also a pioneer in field-based learning, really fun specialty. She taught a course at the Hakai Institute up on BC's Central Coast for a number of years. I had the great pleasure to be a guest there once during her course. And more recently, she's teaching at the Bamfield Marine Science Center over on the west coast of Vancouver Island. I've known Deborah for many, many years, working together with her back at West Coast Environmental Law. And we had the really great experience of working together on Smart Growth BC, a nonprofit organization that, as the name implies, promoted and worked with communities on smart growth principles throughout the province. And that's also where I met Ione, and I'll mention that a bit later. So second of all, our second speaker today is Brenda Gartner. I've known Brenda even longer, way back when. Brenda is a partner in the law firm Mandel Pinder, very well-known Indigenous rights law firm here in the Lower Mainland. She has appeared before many levels of court and regulatory tribunals, such as the National Energy Board, environmental assessment review panels. Brenda had a lead role in representing Indigenous clients with the Cohen Commission on the fate of sockeye salmon in the Fraser River. She's a board member of the Pacific Salmon Foundation, and as she just said before this started, passionate about fish. So she may talk a lot about fish. Her topic today is about fish farms in the Broughton Archipelago, which reminds me, I did not say what Deborah's was. Deborah's topic is about modern day treaties and Indigenous food sovereignty. But I just have to say that I had the, again, wonderful pleasure of going on a kayak trip with Brenda and a small group 28 years ago. Can you believe it, Brenda? Up in the area that she'll speak about today. So how amazing that was. And welcome to you, Brenda. And our third speaker, Ione Smith. Great to see Ione and reconnect with her. She also worked with Smart Growth BC back in the day as the Sea to Sky Greenbelt Coordinator and a number of other roles. Ione is a professional agrologist, and she has her own consulting company, Upland Consulting. Since 2017, she's been a member of a unique institution here in BC, the BC Agricultural Land Commission, which she'll speak about today, and the Agricultural Land Reserve, which works as an informal urban containment boundary and is really unique. And I know people from outside BC will be curious to hear about this legal arrangement that's been in place here for several decades. Ione is also the vice chair of the South Coast panel of the Agricultural Land Commission. And as I said, she'll talk about that institution here today. And it's great to see you, Ione. And we did work together back in Smart Growth days, and lots of fun there. So with this powerhouse panel, three amazing women, we are just going to turn it over to them. And the first one up is Deborah Curran.
Thanks so much, Linda. And I'm sorry, I have to join the gush fest because these three women really are mentors of mine, long-standing mentors, even though Ione is younger than I am, smaller too, but younger than I am. And we didn't coordinate, we didn't phone each other and decide on the nice red shirts this morning. But each of them is a real leader in their own way relating to food systems, as you'll hear, and fearless. So, you know, Linda has been a longtime mentor in the public interest environmental law community, working on a huge range of issues from, marine spatial planning to water sustainability, and then also creating compact, complete communities through a smart growth approach. Brenda's work really speaks for itself, as you'll hear when she talks about the Broughton Agreement, and that is the kind of work that she's done for more than 20 years. And likewise with Ione, to be embedded within the best agricultural land protection mechanism from a regulatory perspective that we have in Canada, and to be able to do that from her position as an agrologist who very integrally links agrology with land use, one of the very few agrologists who's able to speak both languages quite seamlessly. It's such a pleasure to be here on this panel with you two. Three. I'm coming to you from the traditional territory of the Saanich First Nations. You can see Pecoles out my back window there, which reminds me every day that the work that I do not only needs to work towards environmental protection, but also acknowledging the authority and upholding the Saanich authority here on the Saanich Peninsula. What I'm going to talk with you about today is a few observations that I have there. It's almost so obvious that it makes me a little bit squeamish to talk about it. But the reason I wanted to talk about it in the context of BC food systems is that it is very much a relatively new construct to just show that there is a very significant disconnect between where the provincial government is, for example, in talking about food systems and how we think about food systems, and where we Indigenous communities are in advancing their own food systems and sovereignty. And I think it falls, this context, I think, then sets it up quite nicely for how Brenda is then going to go and talk about more of a negotiated agreement that got some food systems outcomes. And then Ione talking more formally about the way in which the colonial state or the provincial government acknowledges agricultural land and is protected in a much narrower way. And so in setting this up, the work that, or how I come to this knowledge is that, as Linda mentioned, I've had the privilege of teaching 2 field courses over the course of, the first field course was for 5 years in the Central Coast in Heiltsuk and Wekino territory, and now I'm teaching in New Channel territory on the west coast of Vancouver Island. and with the support of the Hoyet First Nation in Anaklo or Banfield. And so being able to be there in those land and marinescapes and in those foodscapes, the students and I get a very deep and rich understanding from an outsider perspective of how those communities view their broader territory, which from a settler perspective is viewed as crown land. So 94% of British Columbia is the crown asserts ownership over it, or in the marinescape, the feds take virtually all responsibility for at least allocation, not necessarily regulation, but allocation of marine species. So there's this giant disconnect between how Indigenous communities are behaving within their traditional territories and the way in which sort of the colonial state sees them. And you've heard this already from the opening panel to Terry Lynn's beautiful presentation. This is not surprising. But when we go to the west coast of Vancouver Island, we get something that is somewhat unique in that we then enter into a modern treaty context. So a lot of you from the rest of Canada are more used to or familiar with historic treaties. So signed in the late 1800s or early 1900s, they're very general in language, and we have a couple of those in British Columbia, but on a tiny portion of the landscape. So where I am here, the Douglas Treaties on southern Vancouver Island, and then in the northeast, the province in Treaty 8 territory. But the rest of BC, until recently, was unencumbered by treaties. And so most nations are working in a common law Aboriginal rights context, which I'll get into a little bit, which makes it more complex. But if we fast forward then, so for over 20 years, we've had a modern treaty process going on in BC. So the province and the feds negotiating with individual First Nations who choose to enter into that process. And one would expect that what's coming out of that is a bit more of a broader recognition or a more integrated recognition of foodscapes and food sovereignty. But as you'll see at the end, my very obvious observations are that that is not the case ultimately, and that what continues to occur is that nations are governing their traditional territory through their traditional governance systems and Indigenous legal orders, while at the same time doing other things through modern treaties. So there's sort of, not only are there multiple legal orders at work, but even in a modern treaty context, there are multiple things going on that one perhaps wouldn't expect with what the promise of treaty is. A modern treaty is that it's exceedingly detailed, and you would get to those, you'd get some resolution in the way in which the parties were going to interact or create a relationship over the long term. So what I love about this conference is that it's very multidisciplinary, and people are from all across Canada. So what I want to do is just set out some basic principles to give us some context for BC food systems and governance from a state Aboriginal rights kind of perspective or Indigenous authority perspective. And many of you will already know this, so please excuse me for this baseline, but just so that we're all on the same, kind of have the same understanding. As I mentioned, the Crown, so the provincial government asserts ownership over the landscape and water. So water is presumed to go with land, meaning fresh water is presumed to be under provincial jurisdiction by virtue of land. And that in British Columbia amounts to 94% of the landscape. And in other provinces, it's not quite as much, but it's still significant. So the province has virtually complete control over what happens there. And the language that has never been adopted in that conversation, nor acknowledged in court cases, which is again within the colonial construct of what we understand as law, is that all of this land and waterscape are Indigenous foodscapes. And in British Columbia in particular, I mean, everywhere in Canada, we have multiple legal orders operating because we have, state or colonial law. So whether that's common law in most of Canada or civil law in Quebec, then we have Indigenous legal orders throughout our landscapes, and these interact in different ways. But then within that, within the colonial legal order, we have what is an attempt in our Constitution in 1982 to bridge what is occurring, or Aboriginal rights, and what is occurring in Indigenous communities with what the state is doing, or what the province and the feds are doing in terms of making decisions across this land and waterscape. And so many of you have heard of Section 35 of the Constitution Act 1982, often just referred to as Section 35 of the Constitution. And most people say, oh yeah, well, we protect Aboriginal rights in Canada. And that's simply not true. And I think you got that from the first panel yesterday. So in particular, Alan and Darcy's conversation. Section 35 recognizes and affirms Aboriginal and treaty rights. So it basically says they exist. And so what the court cases have done since 1984 then is defined those rights. And in short, you know, in addition to saying Indigenous communities have the right to hunt, fish, and to carry on their traditional activities for food, social, and ceremonial purposes, with a very few of them having commercial rights. You, the state, the provincial government, if you're going to have an impact on those foodscapes or that ability to hunt and fish, you have to consult with those communities and you have to accommodate them in certain ways. So it's that interaction between consultation and accommodation that is the primary interaction historically for the last 30 years or so between Indigenous communities and decisions that the Crown has made. And that's true with both very general treaty rights and also in a common law context where there are no treaty rights, where Indigenous communities assert Aboriginal rights under Section 35, but they don't have them defined under treaties. And so that's the primary interaction, is this consultation and accommodation. It's a one-off. It's like, we're going to approve this project. What do you think of it? Or we have a water license application. What do you think of it? And then it's up to the Indigenous community to then respond. So there's no planning. There's no cumulative effects assessment. There's nothing that treats a foodscape or a traditional territory as an integrous whole that would say what's going to happen over time. Enter into the fray modern treaty rights. And so, you know, since the 1990s, we've been negotiating modern treaties in British Columbia. At first blush, lots of communities jumped on and got into the treaty process. But when they then learned about the treaty mandate of the federal and the provincial governments, which was to take your traditional territory and choose to have control over only a tiny, tiny bit of it, so it's around 2%, lots of communities are no longer negotiating because they don't agree with that particular model. Oh, I'm sorry. What I should also say about context is that within that context that I'm talking about, this consultation and accommodation back and forth, we have a lot going on with Indigenous communities saying, sorry, that's not what we agree to in terms of the way that we govern our foodscape. And so you can see this is just an array of examples of Indigenous communities saying, you know, in our responsibility towards our traditional territories, these are what we expect of you, the Crown, to in how you make decisions. And the article on the bottom, so First Nations environmentalists occupy BC salmon farms, will be what Brenda's talking about. And then, oh, I thought I had a herring one up there from the Haida case, but I didn't. And I believe Carrie Lynn talked about the Haida case yesterday. So this is also within the new context of the Declaration on the Rights of Indigenous Peoples Act here in BC that says that the province will work to align BC laws with the declaration. So in particular, I think, you know, often we talk about the free, prior, and informed consent standard, I guess. So a lot of people, again, like people say that we protect Aboriginal rights in Canada, which we don't. We acknowledge and affirm them. A lot of people say that the Declaration Act is going to implement UNDRIP in British Columbia. Again, that is not correct. The BC government has said they're going to align our laws with UNDRIP, whatever that means. I'm always worried about those wiggle words. Alignment is a very, very general word. And then the other two things that the Act does explicitly is it says that the province can enter into agreements with Indigenous governing organizations for consent-based type processes. and also to delegate authority to other organizations like Indigenous governing organizations to make statutory decisions. Okay, so let's then take all of this quite complex context where lots of different legal orders are operating at the same time, different conceptions of foodscapes. And I'll just give you the example then of the Malnuth Treaty that was signed about a decade ago, and it implicates 5 New Channel nations out of the 12 or so who are in the broader New Channel nations or tribal council and are on the west coast of Vancouver Island. So this is just the southern part. So the Cayucit and Checklisset First Nation are up here. So they were also signatories. Most of the signatories are down here around Barkley Sound, which many of you would know it either as the Pacific Rim National Park Reserve Broken Islands. Many of you have probably been paddling there, and or lots of you would know Tofino and Ucluelet. So this is you know, Pacific Rim National Park Reserve, the amazing beaches, and then Tofino is up this way, up to the northwest. So this whole area, we have 4 signatory nations to the Malnuth Treaty. It's important to note that in addition to sort of the elected leadership that are acknowledged under the treaty, there's also the traditional leadership that governs also in each of these communities very integrally. So the Hatwiya structure across the whole Hahusli, which is the traditional territory of each of the New Channel nations. And you then get, as I mentioned before, the treaty mandate was you choose treaty lands that are a tiny portion of your entire traditional territory, and then you have the other certain consultation rights on the rest of it. The other piece of context is that the Hausat and other First Nations who are non-signatories to the treaty have had successful litigation going on for many, many years around a commercial right to fish all marine species. And there has just been another decision of the BC Court of Appeal upholding that. So the Hausat are negotiating with Fisheries and Oceans Canada around what that means, because the court has said that they have proven that they have a commercial right to fish all marine species, except maybe geoduck. I'm not entirely up to date on that conversation, which was a bit of a side conversation, but maybe Brenda can correct me. And then the other thing is to show that in the preamble to the treaty, you note that the wording that has been chosen, because the Crown would not acknowledge jurisdiction or authority of the New Channels, is that the stated purpose of the treaty is reconciliation, but the language is the prior presence of the Malnuth First Nations and the sovereignty of the Crown, which is problematic in itself. Okay, so just very quickly, I'll go over a couple of pieces of this, or the structure of the treaty before it, which is exceedingly complex, so thousands of pages and many, many appendices. But I want to get to the reasonable opportunity agreement on the traditional territory, not on Malnuth Treaty lands. So the verbiage of the treaty is this is full and final agreement. Each of the Malnuth First Nations, which have been able to gain authority over their Malnuth lands, Malnuth Treaty lands, which were the red in that map that I showed you. So this is the Hoyat First Nations actual lands that they have gained control over, meaning that they have lawmaking authority over it as well. So even if their entire traditional territory is out here and would go way out into the ocean, all of this is still considered Crown land, and that would be where the reasonable opportunity to harvest occurs, but they just have lawmaking authority over these lands. And then in the broader traditional territory, that's the First Nation harvest area. There's a fixed allocation of marine species, so a certain thousand number of salmon per year and other things. And then there are rights to harvest across different scales and species, depending on whether they're migratory birds, whether they're in the National Park Reserve, you know, whether they're in aquatic habitats. So you can see the weirdness of federal provincial jurisdiction bleeds into the treaty and makes it very difficult to actually figure out who can do what where in this larger foodscape. there is no sort of joint decision making in the treaty on the broader territory. There are these joint discussion forums. So there's the Wildlife Council and there's a joint fisheries committee. And ultimately the minister has final authority in whichever area. So then how is it then on the broader traditional territory? So except for that little slice of red over which, you know, each of the communities has lawmaking authority and they govern those lands. In the broader traditional territory, if we're talking about a foodscape, then how is it that each of the communities is able to say, well, we have to still have authority to be able to, or the right to be able to continue to treat this as our foodscape and to hunt and fish in this area. And so what the parties settled on was that there's a number of provisions, I've just included these two. So within the treaty, the provisions say that the Malnas First Nations must have a reasonable opportunity to harvest wildlife within that broader traditional territory that's considered Crown land. So this reasonable opportunity is the language. And then you go into how do you then express that reasonable opportunity? So it's a negotiation. So it's an ongoing negotiation. So if we then plug into, oh darn, it didn't work, sorry. If we plug into then the reasonable opportunity agreement, half a sec here. Oh, I'm not going to be able to do it. Ah, there, that's better. There we go. So if we plug into the reasonable opportunity agreement, the parties have agreed to kind of a process by which they talk about whether the reasonable opportunity is still being exercised or not, is able to be exercised. And what we then have is that the Malnas First Nations and the province meet to discuss in a number of different ways about whether provincial decisions about forestry or approving oil and gas facilities, obviously not in this context, or you know, waste management sites, whether that is having an impact on the reasonable opportunity to be able to carry out their responsibilities towards food systems and their communities. I just wanted to, this is a few of the background provisions to the reasonable opportunity agreement. The reason I think it's very important is that it shows very much that even within this context of the treaty, there are parallel operations of the traditional governance system throughout the entire Hausli, and what the Malnas Nations have actually put in are a few of their Indigenous legal principles around Itzak, so respect for the earth, and Tiship of Sawak, the interconnectedness of all things that drive everything that they are doing. Okay, so what does the reasonable opportunity agreement do? And I'll just spend 1 minute concluding with this and then just provide you with my 3 observations. It really is an information sharing and a procedural mechanism to look at the decisions that are being made in the broader traditional territory and the uses and dispositions of the land that the province agrees to. So the intent is to monitor and assess the impact based on some ecological indicators. But those ecological indicators are not set, as in it's not like the Great Bear Rainforest where the party said, okay, we need to return this landscape to 80% range of natural variation, old growth, in order to achieve the ecological and community outcomes that we desire. So there are no ecological standards in that way. There are standards for monitoring purposes to be able to tell what the impact of the use and disposition of the land based on provincial decision making is. And then there's some enhanced processes for important harvest areas and for significant uses or dispositions like mines or hazardous waste sites. And you note in 4.14 that I've just put there that wording that the province doesn't promise that they can do anything about adverse impacts. So that conversation carries on, the reasonable opportunity conversation carries on in the context of the Houseit litigation, where the courts have found that the nations that are parties to that have commercial Aboriginal rights, at least in the context of marine species. And then we also have the Council of the Hatwiya. There are a number of different sort of collective forums of the traditional leadership who are making their own governance and management systems. And again, this example that I've given you is in the marine context, but it could be just as likely another conversation going on in a terrestrial context. So this is where in 2017, the Hatwiya agreed that only food and ceremonial fisheries would occur within New Channel's territory because the herring are still not adequate at an adequate level to allow a commercial fishery. So just in conclusion, this just provides additional background or context for this complex conversation about food systems in British Columbia. This is a more modern mechanism, as in this is a relatively recent agreement that 5 nations have come to with the province and federal government, but it really does not put any substantive limits on state governments to uphold food systems or Indigenous sovereignty related to food systems. And again, we never see this in environmental law, so it's not a surprise to me. It's just a disappointment that we don't see any ecosystem-specific commitments to Indigenous communities about food security in these intensely detailed modern agreements. So if you think, oh, there's so much to negotiate, we just couldn't get to it. It's like, really? Like food is really the baseline for all of us, is one of the baselines. And so there's a whole lot there that's unfortunately missing. So with that, which is a little bit depressing, we move on to some more interesting things, because I think that what Brenda's going to say is more current and more relevant given DRIPA and sort of the new negotiating mandate of the provincial government, and offers a lot more opportunities for communities to be able to do something interesting. Thank you.
Thank you so much, Deborah. That was a wonderful introduction, and we're just going to move right into Brenda's presentation. So over to you, Brenda.
Thanks very much, Linda. And I want to begin by acknowledging that I am standing on the unceded ancestral territory of the Saanich people. I live here on Gabriola, and I have the opportunity of living amidst an ancestral village and a midden, and I know these ancestors have my number and have kept me working and have kept me alive and guided for a long time. So I want to begin by sending gratitude always to them. And then I also want to express my gratitude to the knowledge holders of Indigenous peoples who have been teaching me for 35 years now on the importance of fisheries, resources, and fisheries to who they are as people and to their sacred responsibilities to their ancestors and the future generations that they have. And all of what I have to say is on is based in their knowledge and their patience with me over the years. And so I very much need to recognize how much they've been willing to teach me. And then, of course, I want to thank the organizers and Victoria. She is the one that has been the most patient with all my questions around how to focus this discussion. I'm not going to use a slide presentation. I often do, but I just want you to listen to me. So just relax. I won't talk for very long, 10, 15 minutes. So you don't have to over engage your eyes. You might even be able to close them and just listen, which is sometimes useful on these Zoom meetings, is not to have so much engagement. So one of the first questions that Victoria asked me to think about was, well, why is the Broughton Agreements important? What's important about them? And I couldn't answer this question without saying a little bit about why fish is important to Indigenous communities of British Columbia. And I want to start by using Hugh Breaker, who's the president of the First Nations Fisheries Council's words. We recently filed an affidavit in the Discovery Island fish farm dispute that's before the federal court right now. And Hugh Breaker, who as the president, summarized it this way. He said, BC First Nations have an integral, deep, and abiding relationship to fish, fish habitat, and fisheries and aquatic resources, and in particular, wild salmon. This relationship is ancient, ongoing, sacred, and reciprocal. And I think that's an extremely important sentence. We could unlock each one of those words and spend the rest of the day talking about them. Rest assured I won't, but it's very important to actually keep in mind that when Indigenous people are talking about their relationship to the fish, wild salmon are a member of their family. They're not a resource. They hold a voice in the decision-making that Indigenous people have to make. Indigenous people have a right, but you will hear in their teachings, there is no right without a responsibility. It's a common law principle that you proceed and you want to access and work with your rights. But Indigenous people want their responsibilities to these members of their families recognized and protected. And it's ancient and ongoing. So often people think it's something of the past. I can tell you that all the fishermen I've been working with, and it started 35 years ago, and those fishermen have my number also. This is not something they think about in the past. They are on the rivers, they are on the waters. They are sometimes the leading fishermen in their communities, without a doubt, for all purposes. And it's reciprocal. They need the salmon to come back, and they need to ensure that they've done everything about it. It's not just a one-way thing where, you know, if you make sure the salmon are there, then they can just fish and take it. It's a very reciprocal relationship. And then Hugh said this, First Nations reconciliation in fisheries. So we hear a lot about the responsibilities for reconciliation that we all have, whether we're individuals or governments or crown corporations or proponents or law students or lawyers, whatever it is, we all have responsibilities for reconciliation. But for First Nations, Hugh says, reconciliation in fisheries includes protecting, he started by that, protecting and conserving wild salmon, reclaiming our role in the management of our territories, including the fish habitat, and meeting our communities' food, social, cultural, and economic needs. Recognition in fisheries includes honoring our responsibilities to the salmon for current and future generations. So if you fast forward to today, and if you all can acknowledge, I don't think it's a debate now that we have climate change and global warming. Salmon, as we learned in the Cohen Commission, is one of the most sensitive aquatic resources to temperature. So when the water temperature change, salmon change. And we have a salmon in dire straits throughout the whole of British Columbia for many, many reasons, as Commissioner Cohen put it. There are only a few that people like to focus on, but there are extremely many reasons why salmon are at risk. And if salmon are at risk, the Indigenous people of this province are at risk. You have to consider that, because if you look at settlements, village sites, all of those, they will always be related to the returning salmon migratory route. There is such an intricate relationship between who salmon are and who the Indigenous people of this province are. And so I wanted to use some words from Les Antoine. I've had the pleasure of working with Les and for him for many, many years. He's a fisherman and a leader in the Fraser Valley, and he's a longtime fisherman, very, very dedicated to the protection of salmon. And he said this about the returning early time Chinook, which are extremely difficult now. He said, today, we're more likely to be warned of the coming of Chinook by the arrival of seals and sea lions who aren't even supposed to be in this part of the river. It's very unnatural. Our old people used to look to certain plants like the wild rose. When the wild rose popped out, we knew the Chinook were coming. Now, the importance of Chinook is extremely relevant in this circumstance because it's the first fish that returns to the Fraser. If you think about your whole communities depending on fish for food security, and you've been through the winters, and then the first fish come, and those oils and those important components of fish. The first salmon ceremony, a very sacred and old ceremony in many, many Indigenous communities in British Columbia, was all turned on the return of early time Chinook in the Fraser. And now, today, they still have the salmon ceremonies, and now they have to share little pieces of fish so that everybody has a taste. So if you look just at that vulnerability, and you consider it, I can now turn to why the work in the Broughton was so important. Because you know, and as I said to them, I could spend so much time just trying to express how much I've learned about why salmon is so important and so integral to who Indigenous people are. They could give you many stories. They could give you many teachings of what salmon teach people on how to live together in a respectful way, in a collaborative way. In 2017, I was approached by the hereditary chiefs of the Quitsantainic people in the Broughton area. And they wanted me to help them implement what would be a new way of trying to reach resolution of a very old dispute. So disputes, and Deborah had a wonderful picture of how many people have been fighting on the ground, in the water, and in the courts on fish farms in the Broughton. And the nature of the dispute was, are those fish farms, which were put into the Broughton without the consent of the nations, they were located, and they still are located, on out-migrating routes of wild salmon. And over the last 30 years, these nations have watched their salmon decline in numbers. The out-migrating salmon would leave, they came back, they wouldn't come back, they were coming back more and more. And so many different scientists have been working with the nations, and many different scientists have been working with the companies. And there has been a scientific debate about whether or not these fish farms were having impacts on salmon, wild salmon, for a long time. It culminated in the work that we did in front of the Commissioner Cohen. And at that time, the scientists were not prepared to come to agreements on the nature of the impacts. And so we had books and piles of reports that said they were impacting the salmon. And they had similarly books and piles of reports saying they were not impacting salmon. And the Indigenous people were going, how can you add all that waste into our waters? How can you add all those antibiotics and all the other things you're adding as a result of these fish farms and it not have an impact? If you're managing from an ecological perspective, they've watched the seabeds underneath these farms be destroyed. They have all kinds of very clear evidence from their perspective that there is a direct route. Fast forward to today, even after these agreements, continuing work, and there is very little debate anymore about whether the farms are having an effect. And that's why finally both the provincial government has made some very strong statements on the increasing. So the nations had been on the ground, there were protests, there were people willing to risk their lives around these farms, and they'd been to court many times to try to get these farms removed. And the most recent one was on behalf of NAMGIS. And that the NAMGIS challenge on the fish farms went as far as interim injunctions and permanent injunctions have 3 tests. Is there a fair question to be tried? Yes. Is there irreparable harm? In the NAMGIS case, the court even found irreparable harm. Yes, that if these fish continue, it has the potential to irreparably harm the Indigenous people in their exercise of the right. But the balance of convenience, the court was very concerned about removing farms that had been there for 30 years. And so by the time they got to the balance of convenience test, once again, the court didn't have, in my view, the willingness to move forward, and left it for other tables, including ours, to try to resolve it. So the nations asked me, is there a way to resolve this issue and to get these farms leaving our territories with some certainty? The courts are very uncertain, and so they wanted certainty of outcome. And in my view, the most safe way of certainty of outcome is if you use the standards of the UN Declaration of the Rights of Indigenous Peoples, you recognize them for who they are, an order of government in their territories, with a deciding voice in what happens in their territories, and a sacred responsibility to look after them. So the hereditary chiefs asked me to assist them in a process that had already begun. Premier Horgan had arrived in the Big House in Alert Bay in October of 2017. We didn't have DRIPA yet. We had a commitment by the province to begin to implement the UN Declaration of the Rights of Indigenous Peoples. And we had 17 tenures that were up for renewal, provincial tenures. All 17 were up for renewal. So Linda, when we went through the Broughton, there weren't all those tenures yet. There was just some of them. But 30 years later, there were over almost 20 fish farm tenures in that area, and some of them very large tenures where we would have had a very different kayaking experience if we'd gone through Broughton before this agreement. In January of 2018, by then, fast forward, in addition to being hired by the hereditary chiefs of the Quetzaltenic, I was hired by the chief and council of the Quetzaltenic. So I had a joint gig, as I call it, acting for both the hereditary chiefs and the elected chiefs. I stress that because a lot of times there's a misunderstanding that those parts of the governance are different, because we often only hear about it when they're not working well together, but there are lots of times when they work very well together, and there's lots of respect. Yes, there's new work that has to be done to understand how those voices are heard, but in this case, both the elected chiefs and the hereditary chiefs had direction from their community. They wanted the farms out. Enough was enough, and that they were to work together. And so my job was to take direction from both the hereditary chiefs and the elected chiefs, and we figured out a way to do that. So in January, the province committed to a letter of understanding, to enter into an agreement that was consent-based as the standard. And it took us from January till June to negotiate a letter of understanding, which set out the principles and the approach that would be used. And in order to achieve consensus recommendations that would go to both the provincial decision makers and the Indigenous decision makers. And that the role of consensus recommendations is an extremely important tool as we begin the growing pains of recognizing Indigenous decision making. That it's not all about right away delegating to a single decision maker. It's about recognizing that we are in a pluralistic society. We have been, and that those decision makers, if decision makers of any number of governments receive consensus recommendations that have been built through a legitimate, fair process, we're going to help governments work together. And so the true work that happened was well, all of it was work, but the initial work was in the development of the letters of understanding. And I want to just mention a couple things about that letter of understanding. The letter of understanding acknowledged that each government had internal processes to get mandates. So it wasn't as if those of us showing up at the steering committee were going to carry right away from the beginning all the mandates that were required. Far from it. Like any other government, we were going to have to go back and talk to the hereditary chiefs. We're going to go back and talk to the elected chief, maybe even communities, just like the province's reps would have to go back and talk to their senior advisors and eventually cabinet in order to get mandates and in order to reach outcomes. The next thing that we agreed to from the get-go was that in the application of the precautionary principle, This is something that is going to show up more and more for lawyers and policy people throughout the province, is the application of the precautionary principle. DFO has it as a legal standard or a statutory standard. So you might say, oh, well, that's simple. We'll just apply the precautionary principle. Please acknowledge that the precautionary principle includes a risk management. Do we have enough information? And if not, what do we do about it? And people have different risk tolerances. And so that acknowledgement of the different perspectives of risk became extremely important. So fast forward, what happened? We came to consensus recommendations. Those recommendations resulted in 10 of the fish farms were decommissioned immediately, and 7 were to remain for 5 more years, and that the nations had to enter into, as a term of the tenure from the province, an Indigenous monitoring and inspection plan. And so for the remaining 7 farms that are still in place, the Indigenous nations have now entered into an agreement. It took another 6 months after the consensus recommendations were accepted. The nations then went into negotiations with the company on what standards of monitoring and compliance were necessary for the remaining farms while they were in place. And so that's where we are right now. That agreement was an extremely complex agreement. It set the nation's standards for things like acceptable, why can't I remember it? Acceptable standards for the conduct of the farms, and it has detailed schedules that very much are like regulatory schedules on what the farms would have to be, what standards for lice, what standards for other components of the farms would be necessary. That agreement is a term of their tenure. Abiding by that agreement is a term of the tenure. And so we have both the contractual obligation and the industry being very careful about not wanting to breach their tenure. I think my time is very close to being up, and Linda's nodding, so I'll stop there to just say that these 7 farms are being watched. The nations, of course, are developing all kinds of capacity to be able to monitor complex farms like this. They've had to develop a new relationship with a laboratory to get independent studies done of the farms, because they had a long history of not trusting DFO's laboratory results on many things. And so there's been a huge capacity development. And so implementing these agreements are much harder than negotiating these agreements, but they're doing it, and it's working. And there is no agreement yet of whether any of those farms would stay past the term of the current tenure. And I'm confident there'll be quite active discussions about whether that will happen at its right time. So I'll stop there and look forward to questions. Thanks very much for the time.
Thank you. Thanks so much, Brenda. It's a fascinating story, and you've been right at the heart of it. So it's wonderful to hear your perspective on how this agreement has come about and what the current status is. So we've heard from Deborah from the academic and practitioner point of view of the broad modern treaties. We've heard from Brenda about a particular dispute and its resolution and the legal mechanisms used. Both Brenda and Deborah have been focused on what is so important here in BC, the marine food web, the marine foodscapes. And now we are moving on to Ione, who will move us back to land and back to farmland, and is speaking from the perspective of a regulator as well as an agrologist. So over to you, Ione.
Thank you, Linda. Can everybody see my presentation? Thumbs up? Okay, great. So yeah, as Linda mentioned, we're going to switch gears a bit and go over to the land. My name is Ione Smith, and I'm a professional agrologist. I'm not a lawyer. I'm just going to say that at the outset. And I'm speaking to you today from the traditional territory of Shishla Nation in the community of Seashelt on the Sunshine Coast. And interestingly enough, Seashelt Nation has been one of the first self-governing the Seashelt Nation has been one of the first self-governing First Nations since 1986, which is kind of cool. So just by way of outline, I think it's really important to consider the fact that the ALR, the Agricultural Land Reserve, as it was introduced in 1973, has since been recognized as one of the most influential land use planning initiatives ever brought into British Columbia and perhaps even across Canada. So I want to take a bit of time to explore the history behind that unique provincial food governance system, and also explore how really it started to shape local land use planning since its inception. And I do want to note that some of the information that I'm presenting is taken from some treasured documents that I have from the late Gary Runka and also Joan Sawicki. So I just want to pay tribute to them, as they were really some of the grandparents of the Agricultural Land Reserve. And then just to end, I'll talk about a little bit some of the current issues and looking forward. And I will try my best to keep track of time. I did start a little timer. So Linda, just flag me if I'm getting close to the end though. So for British Columbians, the mountainous landscape of the province has always held a really special significance, and it certainly adds to our attraction to it as a desirable place to live. But while the province's geography has rendered it Canada's richest and most diverse provinces geographically speaking, it's also somewhat of a have-not province when it comes to agriculture. And so for context, I think it's important to note that 90% of British Columbia is covered by mountains that are at elevations of 1,000 meters or more. And that has resulted in essentially all of the residential, commercial, industrial, institutional, and yes, food production, agricultural uses being squeezed into two very small pockets of flat valley bottoms. As you can see on this map, these two red triangles represent both over 80% of the population in British Columbia, as well as over 80% of our farm gate receipts, and that's located on less than 3% of the province's land base. So that effectively creates a land squeeze unlike anything that we see in other provinces. And the fact that agriculture, though, is still predominant in these areas, which are basically the Okanagan Valley, the Fraser Valley, and southern Vancouver Island, is not a fluke. In fact, it's by design. And we can thank the provincial political will of the 1970s, really, for creating the novel Provincial Agricultural Land Reserve, which has resulted in 4.7 million hectares of land set aside for agricultural use. And in this map, that's represented in the green. Prior to 1973, it was estimated that there were 6,000 hectares of prime farmland being lost to urbanization and non-farm uses in British Columbia every year. For context, that's equivalent to a land base the size of Kelowna being lost every 3 years, or a land base the size of Greater Toronto being lost in less than a decade. There was an acknowledgement by the political will of the day that in a province dominated by mountains and valley bottoms, prime farmland was becoming more and more scarce. But most importantly, the province was seeing that in the face of increasing land use pressures, local governments were proving unable or simply unwilling to hold the line against allowing land conversion from agriculture to other uses which were considered higher and best use, particularly from a tax perspective. And so at a cabinet meeting in 1972, under the provincial NDP government, an order in council was passed imposing a land freeze that prohibited further subdivision or non-farm use on lands that were 2 hectares in size or more, and that were assessed for tax purposes as farmland, that were zoned agricultural by local government, or that were rated as having good agriculturally capable soils as per the Canada Land Inventory mapping. That order in council then became Bill 42, which was the Land Commission Act, and that was subsequently passed in 1973. The objectives of the act were to preserve agricultural land for farm use and to encourage the establishment and maintenance of family farms. So as you can well imagine, the ALR at the time was highly controversial. And within certain circles of BC and outside of BC, the government was praised for their bold action to save threatened farmland. Some segments of BC were outraged, and that included farmers who were furious as what they saw was the removal of some of their rights to make profit off of the sale of their farmland for development purposes. Some of the largest protest gatherings ever held on the lawns of the BC legislature happened in 1973 in protest against the ALR, and I included a couple pictures there. But there were significant features that define the character and the clout of the Agricultural Land Reserve. Firstly, the market mechanisms, such as the purchase of development rights, were rejected in favor of a more straightforward zoning tool This grounded the program on the concept that zoning rural areas to allow for agriculture only and farming compatible uses was really no different than zoning urban areas for single family residential uses rather than industrial or commercial uses. Adoption of this fundamental concept has had a lasting impact on public understanding and acceptance of the ALR even to this day. And secondly, and perhaps most importantly, was the decision to base the ALR on biophysical criteria, specifically the Canada Land Inventory Soils Mapping, which was developed to assess capability for agriculture. And this decision made it clear that the intent was to preserve land capable of food production. Adopting this technical foundation aided in defining a credible zone and in defending the integrity of the boundary over subsequent decades. And this map just shows you that out of all of the land in BC, only 5% is within the ALR, and of that 5%, really only 1% is considered prime agricultural land. So along with the introduction of the ALR in 1973, an independent agricultural land commission was appointed. The ALC, as it's known, is an autonomous provincial agency independent of the provincial government that is responsible for exercising its decision-making authority within the ALR. There's three key roles that the ALC plays. First, it carries out the mandate as set forth in the ALC Act. It also interprets and applies government legislation. And thirdly, it renders decisions on application for changes within the ALR or for subdivision of ALR lands or for exclusion of land from the ALR. Since the 1970s, there have been some tweaks to the initial boundaries through some fine tuning in response to new and more detailed soils information or other information. Some of the tweaks that were more political in nature proved to be problematic, and that included a window of opportunity to allow golf courses to set up shop within the ALR in the 80s, as well as in the early 2000s, in 2002, a government service plan requirement that the Land Commission must consider community need, quote unquote, as a criteria along with agricultural capability when making decisions on applications. These have subsequently been removed. However, it did cause quite a lot of upheaval at the time. More recent changes to the regulations focus on limiting residential and other non-farming uses, such as capping the size of principal dwellings to avoid mansions and rural estates within the ALR. And over time, the public's response to the ALR has shifted from confusion or outright opposition to acceptance and even enthusiastic support. This is evidenced by this photo, which shows, again, people on the lawn of the legislature, but this time they're protesting potential changes that they would see as weakening the ALR. And about 10 years ago, an Ipsos Reid poll was done to get a sense of the support within British Columbia for the Agricultural Land Reserve. And over 95% of respondents either strongly or very strongly supported the ALR. While there have been some changes over the years, the primary purpose and mandate of the Act has been maintained, and it's laid out in Section 6 of the Act. I'm going to read it here. The following are the purposes of the Commission: to preserve the Agricultural Land Reserve, to encourage farming of land within the ALR in collaboration with other communities of interest, to encourage local governments, First Nations, the government, and its agents to enable and accommodate farm use of land within the ALR and uses compatible with agriculture in their plans, bylaws, and policies. And subsection 2 is new as of last year, and that is that the Commission, to fulfill its purposes under subsection 1, must give priority to protecting and enhancing all of the following and exercising its powers and performing its duties under the Act. That is the size, integrity, and continuity of the land base in the ALR and the use of the ALR for farm use. So as you can see, the mandate is not to balance competing land uses. It's not to negotiate conditions under which one might use farmland for other purposes, but it's to protect farmland and to preserve the option for using that land for food production, not only now, but also into the future. I mentioned the ALC's role in rendering decisions through applications. And two critical roles have emerged. And the first is this quasi-judicial decision-making role on the applications. And it has turned into somewhat of the core day-to-day functions of the Land Commission. There have been over 40,000 applications handled to date since 1973 through the Land Commission. Landowners, including local governments and crown corporations, must apply through the ALC to make changes to land within the ALR. And that includes things such as building housing for farm workers or depositing fill or removing soil from farmland. Similarly, applications are also required for subdivision and exclusion of land from the ALR. The Commission has the decision-making role to approve or to refuse these applications based on the discretion of the commissioners and their read of the Act and the regulations. Their experience provides an ability to place an individual application within the larger context of the region and also provincially. And I will say that many of the decisions that have been either appealed or brought to judicial review have resulted in simply serving to strengthen and clarify the role and authority of the ALC. So there's no harm in judicial reviews. There's no fear in that because it helps to underscore what the real role and clarify some of that for the Land Commission as well. But a second major focus area of the Commission's work has been the review of local government land use policies, plans, all from the perspective of agricultural land preservation. And this, in my opinion, is where some of the greatest impact of the ALR has been witnessed in terms of food systems planning and governance. Right from the establishment of the ALR, the need for the relationship between the Act and regulations and local government plans and bylaws was abundantly clear. There are more than 150 different local governments containing ALR lands, and that includes over 115 municipalities and 27 regional districts. The regional districts on this map are delineated by the dark gray lines there. Local planning, therefore, plays a really critical role in protecting the ALR, and I'm going to talk a little bit about that. So the potential for the ALC Act and regulations to come into conflict with one another is directly acknowledged within the Act in Section 46. I'm just going to read these two subsections. So a local government bylaw or a First Nation government law that is inconsistent with the Act, the regulations, or an order that the Commission has, to the extent of the inconsistency, has no force and effect. And without limiting subsection 4, a local government bylaw or a First Nation government law is deemed to be inconsistent if it allows the use of land in the ALR that is not permitted under the Act, or even if it contemplates the use of land that would impair or impede the intent of the Act, the regulations, or the order, whether or not that use requires the adoption of any further bylaw or law, the giving of any consent or approval, or the making of the order. So what that effectively means is that local governments must work with the ALC in order to adopt local plans and policies that are aligned with ALC acts and regulations. In the Local Government Act, it is required that local governments send regional growth strategies, official community plans, and zoning bylaws to the Land Commission for review and comment prior to adopting them at the local level. This has been a little bit hit and miss over the years, but improvements are happening. In terms of current issues, there are a number of them. Legislation and regulations can somewhat be vague. For instance, one definition of composting can be interpreted differently by farmers, local government, and the Agricultural Land Commission. There are several definitions like that that are a little bit confusing. There's also the opportunity for the Act and regulations to be self-interpreted sometimes by local governments and approving officers. We sometimes see roads or utility corridors being approved and registered at land titles without direct approval from the Land Commission. There's also the issue where the ALC has to sometimes be reactive to the misinterpretation of land use. And we don't always know what's going on within the ALR because local governments are sometimes approving things. For example, in the past, secondary dwellings could be approved in the ALR, and there was not necessarily a mechanism to inform the Land Commission that that was happening. Also, some of the policies are a bit difficult to enforce. For example, you can have processing on your farm for food, but 50% has to be grown on your farm. And it's really hard for compliance and enforcement to go in and make sure that that 50% rule is being adhered to. There's also, from my experience, this fact that the commissioners are often beholden to legacy decisions and resolutions that were made years ago when there was perhaps a different culture at the Land Commission that might have been a bit more permissive. And so changes can sometimes get stuck. That cultural shift can get a little bit hung up on these legacy decisions that we have to still adhere to. And I know my time's running up, so I just want to end with quickly 3 best practice examples. So I wanted to use different examples from around the province. Starting with Squamish-Lillooet Regional District. The regional growth strategy has a specific goal within it to protect and enhance food lands with the following policy objectives: to support a regional food system that is healthy, accessible, and resilient, to promote growth and development within the agricultural sector, and to support the protection and preservation of farmland and sustainable agriculture as the highest and best use within the ALR. That regional growth strategy went on to inform a number of agricultural plans within the region. So the Squamish-Lillooet Regional District includes Pemberton, which is an important agricultural area, as well as the Squamish Valley and the Lillooet area. And I think I saw Sarah Petznick's name on the list of attendees. So she is the executive director of the Lillooet Agriculture and Food Society, and that society was the creation of that study was a direct result of the agricultural plan. So these agricultural plans were made possible due to the fact that the regional growth strategy really spoke highly of agriculture and the need to plan for it. Secondly, I wanted to talk about the district of Saanich, which is where near to where Deb is located today, just outside of Victoria. Saanich was one of the first communities to actually have an urban containment boundary within the province, and it's really stuck to it over time. Within their official community plan, they have policies that limit growth within the urban containment boundary, that support the retention of rural and farmlands, that do not support exclusion or subdivision of ALR lands unless specific extraordinary criteria are upheld, and that provide provisions for buffering of land within the urban sides to protect farmland on the ex-urban side. And so their OCP also led to the creation of an agriculture and food security plan, which has some really great specific recommendations and implementation plan within it. And a unique factor was that the plan was used to then hire a food security coordinator for the district of Saanich to implement the plan. And then lastly, I want to touch on the city of Kelowna. So as you can imagine, Kelowna is historically an agricultural community. And in fact, 55% of the land base is agricultural or in the ALR. And overall, the agricultural plan provides clear policies to serve and protect and promote agriculture, including 33 specific updates to the OCP that were recommended. And all of those were done within the first year after the adoption of the agriculture plan. There was also a detailed development permit area for farmland protection and this really unique vulnerability map, which I've shared here. So here, I don't know if you can see my mouse, but this is Lake Okanagan. These gray areas are the urban part of Kelowna, and anything sort of light green is agricultural or in the ALR. So this blue line here delineates areas that are highly vulnerable to potential incompatibility or conflicts between urban and agricultural areas. So they were able to look forward and plan ahead for what may happen down the line when they're doing their planning for food systems and also for urban growth. So I just wanted to highlight those 3 best practices. And looking forward, I think it's clear to say that the best protection for the ALR has always been good urban planning. We need to have a relationship with local planning that's important because of the byproduct of the ALR that has been to lead to stronger food systems, but also stronger containment boundaries at the urban level. There has been a cultural shift from just the protection of the boundary of the ALR itself to looking at what's happening within the ALR now, the use within, and making sure that that's compatible with farming over the longer term. And that's also been informed by jurisdictional reviews. The ALR really is a positive case example of interjurisdictional food system governance, and it can be seen as a positive example across Canada, I think, and it's quite unique. It'll be interesting to see how it does evolve in the future. It's always evolving. It's nearing its 50th anniversary. But despite fluctuations over the years, in the North American context, it does remain one of the most unique examples of a provincial level zone for farmland protection so far. So that's it.
Thank you so much, Ione, for that.
That was my alarm.
You made it. Thanks so much for that whirlwind tour of the ALR and the ALC. And I know everyone will be fascinated to hear about it if they didn't already. I think we're going to move straight into audience questions because we have about 15 minutes, and I see that some questions are coming in already. I'll just start from the top, and one for you, Ione. Poor quality ag lands have been entered into the ALC in exchange for higher quality. Do you have any data over time on the quality of lands in the ALC?
Yeah, so there is some data around the amount of land, and I believe some of the capability there. I can't really speak to that entirely. My sense is that it's actually the reverse, is that over time, because of the fine tuning that happened, particularly in the 90s on Vancouver Island, and more recently in the Kootenays, that fine tuning was done based on better soil capability or higher resolution mapping, and they were able to essentially identify lands that probably shouldn't have been included in the first place. Some of the best capability lands that have been excluded were done through order in council, and that's over in the Peace region for the Site C Dam. And also there have been, in some cases, that's happened for treaty negotiations. Actually, Tsawwassen First Nation, a lot of those treaty lands were in the ALR on prime farmland, and that was excluded through order in council as well. So it sort of depends the way you look at it, and I'm not sure how that stacks up in terms of each category, but when there is big pieces of good land, it's usually for specific reasons like that. Linda, you're on mute.
I know. Sorry. Next question. We're just going to go in order. And so next to Deborah, and then after that, I will ask Brenda to take a crack at the third question in the chat, if you can see it. So over to you, Deborah.
Yeah, so if everyone can just have a look at the chat. So Kathleen's asked a question about a fantastic article published a number of years ago in BC Studies by a couple of Indigenous scholars and community members who note that the Crown actually has no legal basis for colonization. And unfortunately, that is the power of colonization, and that we live in a colonial context, in particular in British Columbia, where most communities don't operate with treaties. So they never agreed to the Crown coming in and behaving as they are, nor were they conquered. And in that way, then we have a political and economic system of colonialism that continues to impose, what was standards that were brought over by Britain onto communities, Indigenous communities that don't agree to that. So I take, if you want to dig into the article, it's well argued and is, I think, very difficult to refute from the Crown's perspective. But that is then, it points out perfectly the underlying basis of colonialism, which is to simply impose a political and economic system that then benefits off the use of, in particular, land and waterscape of Indigenous peoples. So there isn't really anything I can say beyond that, because we need to acknowledge that that is the context in which we live and operate, all of us who benefit from it as settlers. I think Brenda's example shows a movement on the part of the provincial government, at least, if not the feds in any near the same way, to move towards a reconciliation of acknowledging joint authority or additional authorities.
Great, thank you. And maybe I'll read aloud the third question from Weihei. How McGill, an outsider's question to Professor Curran and or Ms. Smith. Sorry, I punted that over to you, Brenda, but I think you could all answer it, and maybe I'll ask Brenda to go first. Aside from treaty rights, what if property rules go directly to fee simple in marine or agricultural land for Indigenous peoples? Would that better improve the foodscape?
That is a very complex question, because there is a lot of fee simple agricultural land that Indigenous communities own. So the Tsawwassen First Nation, for example, under their modern treaty, got a whole bunch of land that was in the ALR. So I think the point is that it's up to Indigenous communities to decide how they want to hold land and the form in which that takes in the governance over which that then occurs. So see, it's important to understand that the fee simple is a colonial construct. So by simply calling something fee simple, although we see it as ownership and control, it is a colonial construct and comes with its own restrictions. So I think it's really important to simply say it's up for Indigenous communities to govern their food systems that they want, and more importantly, for the provincial and federal governments to acknowledge that the entire province is an Indigenous foodscape and needs to be treated as such.
Yeah, the only thing I would add to that is that, if ALR kind of is in the same place as a reserve land, then the ALR really has no force and effect, because the federal reserve lands kind of supersede it. However, if those First Nation communities, like Deb said, do purchase fee simple lands, then which happen to be in the ALR, then the Act and regulations do have force and effect. So, and that's kind of going on to the next question, I think, that Stefan had about how the ALR's preemptive invalidation is consistent or not. So it's complicated. It's the short answer. There's if it's reserve lands, then basically there doesn't need to be an adherence to the Act and regulations. If it's outside of reserve lands, then there does. And just, with my consultant hat on, I've been able to work on quite a few projects recently with First Nations communities looking at food systems projects that are outside of the ALR. And so there's lots of opportunity, obviously, to promote food sovereignty and to create a more food resilient community, whether or not there's technically ALR land. But yeah, I agree with Deb. Like it's up to the communities, obviously, to determine their path forward on that.
It's funny because those two questions touch on the greatest areas of misunderstanding and lack of understanding in kind of the local government realm in governing food land. So constantly I get questions, I'm sure you do too, Ione, about what is local government jurisdiction? Like, we can't tell anyone on ALR not to do anything because it's its own provincial regime. And then always get questions as well, how do Aboriginal rights express themselves, or how do they operate on the broader landscape?
Great, thank you. And maybe I'll pose one directly to Brenda, just because I know you didn't have time to get into all the details of the Broughton consent agreement. And I just wonder if you could touch on the most recent challenge by the fish farms to the process, the judicial challenge. I don't know if you're directly involved in that one.
Yeah, I've been retained to represent the BC Assembly of First Nations and the Union of BC Indian Chiefs and the Summit, who have come together to intervene in the current legal challenge that's occurring. And that's a legal challenge to decisions in the Discovery Island. So not in the Broughton. There are no legal challenges in the Broughton because the consensus recommendations were accepted by industry in the Broughton and they're being implemented. So that was an important point that I hadn't covered in the work that I did, the presentation I did. So the Discovery Island DFO decision making, so the federal government, not provincial government, important distinction there, was not a consent-based approach. The Department of Fisheries and Oceans refused to use a consent-based approach, even though they were requested by the nations directly impacted by the Discovery Island decisions. And so they waited till 3 or 4 months just before their decisions had to be made and entered into a consultation process with the nations. They consulted with the nations whose territories are directly part of the Discovery Islands and with nations directly impacted by the migratory returns of the salmon. And fast forward, there was a decision by the the Minister of Fisheries to not allow the reissuing of tenures, not tenures, sorry, that's province's decision, operating licenses and transfer licenses for the Discovery Island, and to phase them out. And the proponents in that case have filed a judicial review with the federal court, challenging that decision as being unrational and without due process. And their challenge has included trying to keep First Nations out of the courts. So the nations directly involved in the consultation sought to become a party and intervene. And so far the federal court has not let them in, and they have not made a decision on our intervention. It's a very interesting case about what obligations the federal government has to proponents after they've engaged in consultation with the nations, because the nations were very clear that they did not want those tenures to be, or the permits to be issued. And we were all, I think, pleasantly surprised that the minister accepted the views of the nations. But then the industry said that they didn't have a reasonable opportunity to be heard on that. And so they're challenging that. In the Broughton situation, as an example, we made sure the nations had, the proponents had a reasonable opportunity to be heard right through our process, which is an extremely important part of free, prior, and informed consent and nation to nation and government to government processes. Administrative standards are going to have to be met, and they can be met and will be met. They're not, it's not if, you know, I was concerned, and it'll be interesting to see what happens in the federal courts. So I hopefully, Linda, that gives you a little bit of sense of what's going on there.
That's great. And I know we're almost at time, but maybe I'll ask each of you, I think you've done an amazing job of talking about the complexity of BC food system governance. And what really stood out for me is just the complexity of different governments working together, Indigenous, federal, provincial, municipal. So just put on your look into your crystal ball, and what do you see lying ahead for BC food system governance in the next few years? What significant opportunities or changes? I know that's a pretty big question, but some sort of teaser to leave us with.
I'm happy to jump in just because, you know, we always want the watershed-based context. So, you know, we have these different levels of government doing different things and there is no coordination. So water is the thing that will pull everybody together, in my view. And we're increasingly having water conflicts and shortages here in BC. So if we could all get together and do water sustainability plans, which can acknowledge Indigenous authority, that would then operate in parallel to all of these other uses, we would go a long way. And WSPs under the water sustainability plans under the Water Sustainability Act are able to affect other land use decisions, so forestry decisions, mining decisions, while also then upholding agriculture as a specific and valued use that is above other uses to a certain extent.
Yeah, I totally agree with you, Deb. I think it'll be interesting to see if the Coxsila watershed on Vancouver Island becomes one of the first, right, to get forward with that water sustainability plan. I think climate change, you know, vis-a-vis the agricultural land reserve and what's considered capable areas of food production is going to be really top of mind for the Land Commission to wrap its head around. We've relied so often on soil capability mapping, but there's also climate capability mapping that was done at the same time, and those need to be updated, in my opinion. We might see lands further to the north become more capable of growing a variety of crops. We might also see lands in the south, because of drought, because of flooding, have more limitations to food production. So it'll be interesting to see how the Land Commission deals with these types of technical information and reports, and how much it gives weight to those in its decision making in the future through the lens of climate change.
I see that one, and this actually pulls both of those comments together. I totally agree that water management, ecosystem-based water management is a critical component of the work. But where I see an interesting tension is between wild food and grown food. And the wild foods that Indigenous people have relied upon for centuries and centuries in this province are increasingly at risk by not only climate change, but ongoing development. I'm currently in the midst of a dialogue between a proponent and an Okanagan nation, you know, where less and less lands for wild foods are even available, and yet development is proceeding because of human population. And so that tension between what levels of protection we will provide to wild foods and how we will provide them, and what the trade-off will be for domesticated foods around that, I think is increasing. And we will also see that in the blue economy. And so this increasing interest in growing food in the marine environments, and what the effect of growing food in the marine environments will have on the wild foods, and where we'll set priorities there, and how we'll set priorities. Those are very, even in the area of fisheries and what we're doing with salmon, very, very difficult questions for even the nations that have been so dependent on the wild, because they're seeing less and less of them.
Thank you. I think that's a great ending. Lots of food for thought. I don't know how many times that phrase has been used in this conference, but lots to think about as we move into the break and the lobby room. I just want to thank you all so much for sharing your experience, your deep wisdom, and your wonderful perspective on these complicated topics. Such a pleasure to be here with you. And I also want to thank our hosts, Canadian Association of Food Law, and particularly the UBC Center for Law and the Environment. And I have to do a special shout out to Victoria Bayless on the logistics front for managing to graduate from law school at the same time as doing this complicated program, and to the entire organizing committee. So thanks again, but big thanks to our panelists today. And I don't know if you wanted to say anything about the next steps, Victoria. I'll pass it to you.